Thank you. It was a real pleasure to be invited by Tom and Sarah to moderate this panel on innovations in software and mobile OS platforms. Just a few kind of introductory remarks. I'm going to take a slightly different tack than Josh from earlier today. Mobile platform is the development of mobile platform computing is an incredible example of innovation in the high-tech industry. I mean, here in the mobile platforms are a combination of the developments in a multiple set of areas in a high-tech. Wi-Fi with the CDMA and new developments in 4G, of course, the expansion of the internet with social networking sites and other types of resources like YouTube. And of course, the development ultimately in the hardware side of smartphones. The best example of this expansion, of course, is the iPhone and iPad. As was just mentioned, you know, there were no iPhones, there were no smartphones 4.5 years ago. And yet it's almost impossible for us to imagine today living without them. And 15 years ago, if you had said to people, in 15 years, people are going to be surfing the web, checking their email, playing games, you know, connecting with people, you know, in other continents on their phones, someone would have been looking at you and wondering what drugs are you taking. Just to give you a sense of this expansive development, in the 4.5 years, the mobile platform industry for Apple alone, so the iPhone and iPad, in 4.5 years went from producing $0 of revenue for Apple, because it didn't exist, to now producing $65 billion a year in revenue for Apple alone. I mean, that is just incredible, unknown, I think, in history of commercial development. And so unless you are, of course, living under a rock, that's somewhat 20th century. I think in the 21st century, maybe you should say, unless you've been living under an old IBM mainframe or a Gateway notebook computer from 1994, you know, of course, with the development of mobile platforms comes the smartphone wars. Precipitated largely by Apple and Steve Jobs' infamous statement that, quote, "I'm going to destroy Android because it's a stolen product. I'm willing to go thermonuclear war on it," end quote. And he got his thermonuclear war, at least Apple has in his absence. So everyone is in fact suing everyone. Apple, Microsoft, Motorola, HTC, Samsung. And these are in fact patent lawsuits because they represent property claims in the various components of the platform system that I just summarized to you. And in fact, they represent not just patent claims, but patents in software and in business methods. And this is significant if only because these represent two recent extensions of the patent system to innovation. Software patents start in 1981 and don't really come into true existence until 1994 for pure software patents. Business methods aren't permitted to be patented until 1997. Complementary to this development in the patent system, of course, is also the recent rise in prominence, if only in the public mind, of patent holding entities and the role that patent holding entities have played in the recent patent litigations, particularly in the smartphone wars. Well, today we have two very distinguished and prominent economists to talk today about these legal developments in patent law, and as to whether they have in fact fostered innovation and thus made possible this massive creation of new value and wealth, or in fact instead have hampered it and undermined it. We'll be speaking first as Anne Layne-Farrar from Compass Lexicon, and of course James Besson, professor at Boston University School of Law. And of course, I won't recite their numerous prestigious awards and degrees and honorifics that they have obtained in their experiences. Feel free to use your mobile platforms to access the internet and to obtain this information just after the panel. So without much further ado, Anne.
So I'm talking today about a paper that should be in your packet. It looks at different kinds of business models and how those business models interact, especially in patent acquisition and litigation, of which we have seen an awful lot over the last year. So first, just a quick lay of the land, give you the cast of characters we're going to be talking about before we launch into what these guys are. We have patent trolls, patent giants, and patent dwarves. The trolls I think we've heard about already. These are the non-practicing entities that are charging a toll for something they did not create and which they were likely holding on to for a while until the price was right. Then you've got the giants, who are the large, vertically integrated players. They have big patent portfolios of their own and products that practice those. And then you've got this new category, the dwarves. They're large, vertically integrated firms as well. They may have big portfolios, but not in industries that they are making an attempted entry in. And that's the key distinction there. So who are these guys? Well, first, the troll. Actually, I want to step back from that name. It's an awful lot of fun to talk about trolls, but I think it's been used so broadly and ambiguously that it's lost a lot of the content. And really what we're talking about here is not a non-practicing entity. You can't call all non-practicing entities a troll. There's a great variety of what would be considered a non-practicing entity who bear no relationship to the charging the toll from and popping out from the bridge. So I prefer the FTC's term patent assertion entity here because it distinguishes among different kinds of non-practicing entities. You've got several of which are very pro-competitive, productive members of the economy, like universities with their technology transfer offices, and R&D specialists who are indeed creating lots of stuff, just not making products that practice them. So the paper starts out with a literature review of the empirical studies on patent assertion entities, and what kinds of things can we learn from looking at this literature to characterize who's a PAE. Well, first is very few of them are public. There's a couple, but most of them are privately held, and they favor secrecy. And indeed, they use very complex corporate structures in order to do so. Many of them have hundreds of subsidiaries or affiliations and may create new ones each time they get a new passel of patents. And it's those affiliates and subsidiaries that are going out and doing the litigation. So it can be really hard to tie back who's suing whom, which patent assertion entity is behind what particular lawsuit. Of course, everybody knows these PAEs do favor litigation, and in particular, they often seek injunctive relief. As a little digression here, I think it's important in this debate over the good and the bad of patent assertion entities to recognize that injunctive relief is not automatically granted. Frequently in the debate, people refer to the threat of injunction as a nuclear option, but it's only a credible threat if there's a chance that the party seeking it is going to get it. And that, I think, is often lost in the debate. One last characteristic that emerges from the literature is that patent assertion entities tend to sue multiple defendants all at once. And these defendants tend to have nothing more in common other than the fact that they're accused of infringing the patents. Who are the giants then? These are the big firms that I think learned very, very quickly from the PAE business model and embraced the new world order of IP that came about in the 80s and 90s with all of the different legislative changes, the creation of the special court, and things of that nature in the leading cases. So these are the firms that learned pretty early on, and some are still coming along, that patents could be used for more than just protecting the products that you make. And they could be used for more than just cross-licensing with other big vertically integrated guys. You could actually go out and actively license your portfolios, particularly when it came to your non-core technology. And maybe things that came out of your R&D department that were just byproducts. You didn't know you were going to need them. You decided you don't need them in your product. No point in just shelving those and ignoring them. No, you can license them and at least get some revenue stream and some return on that investment. There's a couple of really good examples here, and we've already talked about one several times today already. IBM and Texas Instruments, both, they hold massive patent portfolios on the order of 40,000 some granted patents. They are both actively licensing those patents, and they are active litigants too. They are not simply defendants against non-practicing entities or PAEs. They go out and sue other people too. In the discussion of who's a patent troll or a practice or a patent assertion entity and who are these manufacturers, there's often been an undertone in the debate about companies that make stuff versus companies that don't make stuff. And the ones who don't make things, products or things that we can see and touch, are inherently suspect. And I think you even see that in the Supreme Court's ruling and Justice Kennedy's concurrent statement in the eBay decision, where he's bemoaning the emergence of this industry where it's patent licensing and earning revenues on licensing that's the revenue generator in this industry, and not the making of stuff, as if you don't make stuff, it's bad. I think that's a really biased view, and I think it also ignores decades of antitrust history. And in particular, there are threats and antitrust risks for the giants, just as there are for non-practicing entities. For example, we have things to worry about like predatory litigation, where a practicing entity can use litigation to foreclose a new entrant or at least to weaken competition. We have things like licensing holdup, which I know has been discussed by and large amongst non-practicing entities suing practicing entities, but when you step back and look at the incentives of these firms, it turns out that vertically integrated firms who have products in the downstream market actually have quite strong incentives for licensing holdup in order to raise their rivals' costs. So the point here is that patent can be a tool of good or evil in anyone's hands. And it doesn't matter the business model of that patent holder. What matters is their incentives and their ability to misuse or use those patents constructively or destructively. And I think that sort of reinforces some of the comments that John was talking about business model neutrality. I think we need to remind ourselves of these things when we get all caught up in the patent troll debate. And lastly, we have our third character, which is the dwarf. These are the large, well-financed firms with recognized brands, but they don't really have a meaningful patent portfolio specific to a new market that they're entering. And this is where we get down specifically to be talking about wireless and mobile, because there are three really good examples here that have already been mentioned today. Microsoft developed its Windows CE operating system. In 2002, it had a particular one for smartphones. Of course, Apple changed smartphones forever when it introduced the iPhone in 2007, and then the very next year when Google introduced its Android operating platform. So these dwarves entering the wireless market, they're giants elsewhere. They weren't giants. They weren't even existing in the mobile space, upset the entire equilibrium of the market and created the great patent bubble of 2011, as the Financial Times referred to it. I think they could have probably said the great wireless or mobile patent bubble of 2011, because that's really what it is. So it all started out with Novell. It had filed for bankruptcy a couple years earlier, but was unable to restructure, emerge from bankruptcy. It sold most of its assets to a software company, but it sold its patents separately. 882 patents were sold to the CPTN consortium for, at that point, what seemed like a huge figure of $450 million. Created a big stir, how big this price tag was. And it also created a stir that it was a joint consortium that actually won the purchase of the patents. And the consortium was comprised of Apple and Microsoft. Google was asked to join, but it decided that if it couldn't have the patents on its own, it didn't want to bother. Nortel was next. This is yet another auction coming out of a bankruptcy, but of a much bigger scale. And at this point, Novell had put everybody on notice. These things are really valuable. You better pay attention. And indeed, 6,000 patents were put up for sale in this particular auction, and the price was tenfold that of the earlier Novell auction. $4.5 billion were paid for these patents. And the consortium this time was Rockstar Consortium, comprised of Apple and Microsoft again, but this time joined by other wireless players, EMC, Ericsson, RIM, and Sony. Not surprisingly, I guess, because it's a brand new thing to have a joint group bidding on the patent acquisition. Both of these were reviewed by competition authorities. The German Cartel Office took a look. The US Department of Justice took a look. Both were eventually cleared, in fact, not that long ago. And in particular, the DOJ relied on letters of assurance from Apple and Microsoft, promising that they would honor any kind of fair, reasonable, and non-discriminatory licensing terms for any standard essential patents important for the wireless industry, and also that they wouldn't seek offensive injunctive relief. Not that they would never seek injunctive relief, but they would only do so in a defensive manner. Apple and Microsoft, of course, were not the only parties to participate in the great patent bubble of 2011. Google may have lost out in Novell and Nortel, but it quickly found other routes to facilitate its move from dwarf status to giant status. It bought over 1,000 Android-related patents from IBM, and most importantly, it purchased Motorola Mobility, which was just finally approved by the US and European authorities 2 weeks ago, roughly 2 weeks ago, and means that Google now has access to 17,000 granted patents and another 7,500 pending patent applications that had been held by Motorola. Not to be left out, Nokia also joined into the fray in 2011 and transferred 2,000 of its wireless patents to the patent assertion entity Mosaid. This one is a very different deal than the others we've looked at because it's really more like a collection agency agreement. The patents weren't sold, they were transferred, and there's a profit sharing so that any returns, either from litigation or licensing, it's probably going to be litigation, let's be honest, will be split amongst Nokia, Microsoft, and Mosaid. Lastly, InterDigital tried to enter the bubble. It put itself up for sale for $3.2 billion. Google paid a little bit of attention to it at first and then quickly shifted its attention to Motorola. And so by January of this year, without any takers in sight and perhaps the bubble having been burst, InterDigital removed its offer from the table. Now, of course, why expend all these gobs of money and effort on acquiring patents if you're not going to use them? And this brings us then to the courtroom side of the battle. I would imagine most of you have seen a version of this chart. There are like 3 or 4 of them floating around. And I've heard it referred to as the circular firing squad, which I think is a pretty good description. One thing to notice is that, of course, the dwarves are represented here quite heavily. Apple, Google, Motorola, Microsoft are all up there. So this is really, you know, a massive battle over the wireless space. Which brings us sort of to how does all this come together? What is really happening and what triggered all of it? I think that the PAEs come in because they really highlighted the potential that patents had. And it wasn't just non-practicing entities coming and suing people. Once they illustrated that you really could split apart the assertion and the practice of a patent, I think entire industries paid attention and took lessons from that. And that meant that when you wanted to enter a new industry like wireless, where there are big established players who hold large patent portfolios and where standards and patents are very important, you know that you've got to acquire your own. So here come all the dwarves who are entering this market as new players. They had to scramble to build their own portfolios in order to stand toe-to-toe with the existing giants. And of course, at the same time, you've got the giants trying to stop them from doing all this. There's a whole lot of money at stake, as we just heard, a whole lot of money. But it's not just about the money to be had in handset sales. It's really, to go back to the very beginning first panel, it's really a platform battle, right? So the fight is over the entire wireless platform ecosystem. It's happening in the R&D space for innovation. What's the direction of the next generation of technology? Whose technology is going to lead that? It's in the technology licensing markets over who has patents, who can sue whom, who can license whom, who can earn licensing revenues. It's in the product markets over whose products get the biggest share. And in the background of all of this is all the rest of the platform stuff that's going on and all the rest of the money to be made off of that platform, a key piece of which is mobile search. And that explains, I think, the Google and Microsoft interests. because it's, you know, they may not expect to make a lot of money off of handset sales, but they sure do expect to make a lot of money off of mobile. So what do we take away from the exciting events of the last year or so? Well, I think one clear lesson is that the assertion and practice of patents have been irrevocably split. It may well be that this separation was an intent of the original patent law, and as I learned last night at dinner, there have been non-practicing entities since the very beginning of the patent system, but I think it's also true that they have reached an unprecedented scale today that we haven't seen at any other period of time. And therefore that patent transfers, auctions, sales are likely here to stay. I would imagine there will be an increasing trend there as well, because once you recognize that patents in and of themselves, not embodied in a particular product, have a lot of value to them, it's a no-brainer to say, if I'm going bankrupt, I'm going to sell my patents too, or if I've got an underperforming division, I have an easy out to get rid of it, or if I just have some extra assets laying around that I'm not putting into my products, why not make some money in licensing or transferring them? It also means that, of course, litigation is inevitable. I think that's been true all along because patent rights are only as good as their threat of enforcement. If the counterparty knows you have absolutely no power in enforcing it, you're not going to get a license. I think that's pretty clear. In terms of the acquisitions, I think that the Department of Justice's decision to okay the two joint bidding discussions is a really joint bidding on the patent acquisitions is a really interesting one, and could have long-term repercussions. If patents are going to be bought and sold in this fashion, and parties who really need them badly, like dwarves entering a new market, are going to bid things up, then one of the only ways you're going to be able to afford it may be to pool together resources. And so you might see more kinds of joint efforts in that fashion as well. In relation to the Trolls' role, I think that could very well change in the future, because the American Invent Acts, the Patent Reform Act that was passed last year, has one particular aspect to it that I think has the chance of significantly raising the costs of patent assertion entity lawsuits, and that's the prohibition of having multiple defendant lawsuits. It's a lot more expensive to sue 10 parties in 10 different courts, because you've got to pick the right venue and have 10 different teams than it is to lump them all together and haul them off to the East District of Texas. So that has some potential to sort of continue to shift this whole dynamic between the trolls, the dwarves, and the elves. I mean, and the giants. Yeah, that's another paper. Sorry, the elves and the trolls. Yeah, earlier reference. I think the wild card here is what the competition agencies are going to do. They've already signaled for the last decade that they're perfectly happy to intervene when standard setting and standard essential patents are involved. And in fact, there's yet another one investigation of Samsung before the European Commission now. They also signaled that they were perfectly happy to jump in and review the two joint bidding consortiums for the patent auctions. What we haven't seen, at least yet anyway, is their desire to jump in outside of standard setting with any kind of troll behavior. Doesn't mean they won't do it. We haven't seen it yet, and perhaps in industries like the wireless that's irrelevant because the standards drive so much anyway. But I think it's an interesting question about what they could do and how they could do it there. And then finally, just to conclude, I think the one takeaway from all of this activity is that it's a really, really good time to be a researcher on IP and antitrust. Thank you.
I think we'll follow the same pattern from before, where we will have the presenter take questions.
Okay.
You can stand there or you can sit. I mean, whichever's more comfortable. Yes.
So, quick question about the trolls. I completely agree that there's a lot of misuse of
So, frankly, I don't see any problem with the litigation. I mean, I think if you look back to the patent reform debate, lots of people pushing for heavy reforms were bemoaning the fact that not enough patents were tested and not enough patents were invalidated. Well, how do you test them and invalidate them if you don't take them to court? That's a good way to do it. I think that the fundamental complaint against the trolls is that they don't come seeking a license. they come seeking litigation. And so it's more of an extortionary hold-up tactic than it is licensing, distributing IP. I think if patent assertion entity meant they asserted it by saying we want licenses, I wouldn't really have a complaint with that, right? If it's a valuable patent, great, pay a license. If you think it's not, challenge it. In my view, sticking with the theme of business model neutrality, economists have written for hundreds of years about the benefits of specialization and disintegrating, lots of papers from you about the benefits of disintegrating the vertical structures. So why should we think it's different with IP? I don't think it is. I think the real complaint is the hold-up aspect, maybe the no notice, the no attempt at a reasonable license in the first place, going straight to I'm going to sue you and try and get as much as I can, from the cowboys of Texas.
Just standing back from this whole picture, you've got, you use the term, some of these dwarfs that have late entrants that have not contributed to the pool of intellectual property and they have to pay, and there's some that have got IP because they've contributed and they get some returns from it. At the end of the day, isn't this a system that makes a fair amount of sense, and that in fact it's not quite a circular firing squad? In the end, those that are up short have to pay something, but then it goes back to the Mexican standoff of patent peace. So this is really just, cannot not be seen as a balancing up, consistent with efficiency, consistent with rewarding those who have invested in the past, and making those that are new entrants, sure they got to pay because they're lacking some key co-specialized assets. But there's no other industry where we say that the new entrant should be getting a free ride. So what is wrong with this system? Isn't it just a little clunky, but isn't it precisely what we would expect as economists to see?
Yeah, absolutely. I completely agree with you. I think we had an equilibrium. We've had several equilibriums in wireless. You had an early equilibrium with the big vertically integrated players. They had a nice cozy little oligopoly over the GSM standard. Along come the Qualcomms of the world with different business models, throws all that up into the air, whole bunch of lawsuits, whole bunch of patent licensing going back and forth. Things settle down a little bit more. Here comes the next disruption. And this is just the settling out. And why should you expect a party who hasn't invested in the standard setting efforts and all of the IP that developed these extremely valuable platforms? They should pay an entrance fee, right? Just like they would if they had to build a big plant tent or some other industry. So I completely agree.
All right, well, why is it that the 90% of the economics profession seem to think the sky is full?
I don't know, and that's one of the reasons I wanted to write the paper, was to say, wait a minute, let's look at why all this is happening. It's just a temporary reaction to new entrants that had a very different structure, different business models. Google's a very different kind of platform than the platforms that existed before. And there's going to be some dust-ups. Why not?
Yes, in the back.
So, how does this dynamic that you described affect the hobbits? Hobbit is the guy who is...
Oh, I love it. I got to add this.
The individual inventor, this dynamic, imagine in this room somewhere is the next Irwin Jacobs. He's got some technology that
Right.
disrupted things. Would you advise the next... How would you advise the next Irwin Jacobs to take advantage of this dynamic you described?
I think you'd better ask Andre and the other strategists that kind of question. But to address the whole Hobbit issue, there is very, very little empirical research that shows how patent assertion entities, their presence, their success, their failures, whatever, affect the returns and the incentives of individual inventors. There's been a lot of theoretical stuff put out about, oh, well, this could be market making, this gives the individual inventors this way out to monetize their invention, therefore it increases incentives. There's been other papers that suggest, no, those guys aren't getting much. I don't think that empirical question has been settled by a long shot. And so I think in the meantime, what you have to do is, one possibility, and this is suggested by the joint bidding for the patent acquisitions that was just recently approved. You might want to see more joint efforts among the non-practicing entities, among the individual inventors, right, to give them some of this bargaining negotiation power over their patents. Irwin Jacobs was able to do it because he could say, look, I've got patents and I'm going to sue you. That only works if you have funding to get to court. Funding is hard to get these days. So you might have to have more joint efforts at licensing and enforcement. Not on not like a patent pool. I'm not talking about bundling and tying these things together, but maybe just for transaction cost purposes. That might be one solution that you would offer. And PAEs have been held out as that kind of solution for them. I'm not sure that they've lived up to that potential. It seems like very few of them have actually bought a lot of individual inventor patents. Some have, but a lot haven't.
One more question. So in the far back, yes. Can you speak up a little bit? We're having trouble hearing you.
Right.
I guess, is that an incorrect characterization? And I guess the question is this sort of structure of large patent holding deterring innovation and deterring startups?
Well, I think that kind of mafia approach can come from a non-practicing entity or a practicing entity. That's exactly what I was talking about when I was talking about predatory litigation. So my view is these things have happened. They happened before NPEs ever came along and ever got prevalent. Patents can be used for good. They can be used for evil. The law should step back from looking at, well, who's the business holder of this patent, and think about the patent law, about how it's being used. So sure, I think some of the PAEs have been doing that, but I would say some of the vertically integrated firms have done it too. It's this tactic that works until you figure out how to catch them. So I don't think it's particular to the assertion entities or the non-practicing entities.
Thank you.
Thank you.
All right. Hopefully.